this is an interesting topic. The first slide indicates some of the issues that we in America have been dealing with. There's a strong sentiment, I think all of you would agree, that at least those on the religious right feel that their religious liberties are being infringed upon. And I have two purposes for this talk today. One is just to give a background as to whether this is true or not, whether the United States on all levels have been biased against religious freedom, and give you a framework of how to think about that, which is based on the Constitution and also the Supreme Court. And the second, we're going to drill down to a specific case, as Brian mentioned, the Colorado Bake Shop case, which is still pending before the Supreme Court. And as he mentioned, this is a case in which a baker is refusing to bake a cake for a gay couple who has gotten married in another state. And that is an illustration of the sentiment that there's an anti-religious bias in America. So is that true or not? We won't cover every single one of these, but you recognize these as issues: school prayer, teaching creationism, endorsing candidates from the pulpit, display of monuments and nativity scenes, stem cell research, and the rest. So we'll get going. I have a natural break in between the two major topics. And if you'd like, I'll ask for questions before we move on to the cake shop decision. Oops, okay. So it's good to start with the Constitution. And the first 16 words of the Constitution says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So, drilling down, it says Congress. So the first thing to remember is that the First Amendment is about inhibiting Congress. So basically it's a limitation on the Congress's power to legislate. What the religious right mostly focuses on is free exercise. Free exercise, you'll notice that this is the first 16 words. This even comes before free speech and freedom of the press and so forth. So, but there's a tension between free exercise and the establishment. And we want to try to understand today what the founders had in mind in putting these two somewhat contradictory provisions. Free exercise means if you're a religious person, you shouldn't be bothered by the government and how you exercise. Establishment of religion, meaning make no law respecting the establishment of religion, says that, on the other hand, no religion can take the reins of government and say, this is going to be the major religion, or this is going to promote my beliefs. In order to understand this, it is helpful to understand how we got here. And sometimes the religious right tries to portray the United States as a bastion of religious liberty. And in a way it is, but it hasn't always been that way. So, for example, in our own history, you may know these names, Anne Hutchinson and Roger Williams. What these two people have in common are, one, very religious liberals, in the sense that they, at their time, this is about 150 years before the Constitution, they were espousing ideas that were different from the established religious views. So Anne Hutchinson and Roger Williams also have something in common. They were both expelled from the Massachusetts Bay Colony for their heretical views. So that's in violation, I would say, of the Establishment Clause, because you're using the power of the state in order to expel somebody from a colony, which is a pretty major governmental act for what? For heresy, basically. Here's something interesting as well. Let me go back to the Constitution. I didn't mention this. The only other place that the Constitution mentions religion is in Article 6, which says that there shall be no religious test for public office. Right? Self-explanatory. But look at this. This is in 1617 in Virginia. And, oops, I skipped that. Here, sorry, this is in 1780, which is pretty contemporaneous with the Constitution, right? It says basically a person who is for political office has to say, I, blah, 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 do declare that I believe in the Christian religion. That's pretty close. This is in Massachusetts. Let me go back here before, this is earlier. This is the law about attending church on Sundays, right? Every person shall go to church Sundays and holidays, or lie neck and heels that night. You know, the rack, basically, and be a slave to the colony for the following week. For the second offense, he should be a slave for a month, and for the third, a year and a day. And so, mandatory church attendance in America. So, how do we make sense of this? How can the Constitution at one point say there shall be no religious test in Article 6, and on the other hand, right there in Massachusetts Constitution, you have to have a religious test.
Before the Constitution, right?
It is before, but it's pretty close. But it gives you an idea as to the mindset. And one way to understand this is that the Constitution, you have to recall, is the creation of the federal government, right? Before that was the Articles of Confederation. And and one reason for the federal government, well, among other things, is that, you know, the United States, pre-United States, had trouble raising an army, funding the army. And after the revolution, the United States got rid of a dictator, the British government, King George, and it was kind of suspicious about creating a strong federal government, right? So one way to understand this is that the Constitution, which is the Constitution of the federal government, was seen suspiciously by the states. They didn't want the Constitution, the federal government, to have too much power. So while the federal government is not allowed to have a religious test, states may still have, you know, their own religious tests and so forth. So if I'm a politician in a particular state and I have to take a religious test for my state, if I want to be an officer in the federal government, I don't want to have to take a different one. So that's one way to understand it. So it's not that helpful, frankly, to look at the history of the United States in order to understand what this meant by free exercise and establishment. The best way to look at it is to look at the Supreme Court and the cases they have decided based on the First Amendment. So we will, one more slide. This is a chart from a website called procon.org, and this is an indication of the number in these states. These are the 13 colonies. And these are the years in which they had some form of law that had some official support for a state church, right? So in the Northeast, it was mostly congregational. In Virginia, it was another, church. So there was taxation of individuals in order to support either teachers, ministers, or a particular church. And that gives you an idea as to, at least in terms of establishment of religion, what the states thought about. They didn't want the federal government to do it, but they were not so concerned about their own states. All right. Forward fast 100 years later, and the Supreme Court took a major case that interpreted what is meant by free exercise. This is George Reynolds, and he is a prominent Mormon. He was the personal secretary of Brigham Young. Brigham Young, you may know, was the founder of the state of Utah. He was the first governor, and he's also the prophet of the Mormon church back then. And the United States government had passed a law called the Moral Anti-Polygamy Act that President Lincoln signed. And that law basically prohibited polygamy. And the U.S. government has, for about 20, 25 years, until about 1890, 95 or so, put away about 2,500 Mormons for polygamy. They've stripped the territory of Utah of certain rights. And the Mormon church wanted to challenge this, right? And the basis of the challenge is that, hey, the Constitution is up here. It says that Congress shall make no law establishing the of religion or infringing on the free exercise of religion. That's the Constitution. Congress's act is a law, right? The Anti-Bigamy Act. Shouldn't the Constitution supersede the law? So that was a very plain question that this case raised. And so Reynolds was put up as a test case, right? He, through the church, basically advertised the fact that he was a bigamist, he has 2 wives, and he was probably prosecuted by the then federal prosecutor in the territory of Utah, and he was sentenced to 2 years of hard labor and $500 in penalties. So he was challenged, it was affirmed, and it went all the way to the Supreme Court. And the Supreme Court says, no exception. Reynolds loses. So in this case, Reynolds did a good job to assert why this was a free exercise case. In the facts of the case, it says, it was the duty of male members of the Mormon Church, circumstances permitting, to practice polygamy, that this duty was enjoined by different books, among others the Holy Bible, and also that the members of the church believed that the practice of polygamy was directly enjoined upon the male members thereof by the Almighty God, that the failing or refusing to practice polygamy would be punished, and that the penalty for such failure and refusal would be damnation in the life to come. And he proceeded to prove that he was duly approved by the church to do this, that he had went through the steps to get a second wife, and so therefore he did this purely out of religious conviction. So the question raised was this: does the act violate his exercise rights? And the court said no. In this case, it's important, even though it was so many years ago, it does set out some of the framework of how religion is viewed today. So first, one rule says laws are made for the government of actions, and while they cannot interfere with mere religious beliefs and opinions, they may with practices. So this is important because at least the court said the court will never prosecute the state or any government will never prosecute somebody for saying faith versus works or some doctrinal belief that you hold. But it says that your conduct can be regulated by a generally applicable law. And the court went out of its way in many, many pages to substantiate the importance of governing marriage, foundation of society, of morals and so forth, and this is important. So it's really important that the church basically is saying that they're not targeting Mormons. They're basically saying this is the general rule that applies to everybody. It's a civic law, essentially. And it says that if the court would have to create exceptions for one religion but not another, then this basically would say, well, those who do not make polygamy a part of their religious belief, like Baptists, for example, may be found guilty and punished, while those who do must be acquitted and go free. This would be introducing a new element into the criminal law. So essentially, if you're going to make an exception for one church, then you're applying the law unequally from one group to another. So the rule that is very commonly raised from Reynolds is that to permit this exception would be to make the professed doctrines of religious belief superior to the law of the land, and in effect to permit every citizen to become a law unto himself. So that is a general rule that in some ways still applies today. Forward fast another 100 years or so, and this is a more modern case, but the facts in some ways are fairly similar, at least the case and the law applied. So Smith is you can tell he's a Native American, and when he was a child, he was taken away from his Klamath tribe in Oregon and raised in public school with a Western family, and he had a hard time. He fell into drug and alcohol, and it was not until he was in his 50s that he rediscovered his Klamath roots, and by that time he was a drug and alcohol counselor, and he found himself really in his newfound religion based on the Klamath Indian tribe, and as part of that exercise he takes a peyote, right, as part of the religious exercise, and because of that he was fired from his job, and when he applied for unemployment compensation from the state, he was denied. And the reason he was denied was because he was fired for misconduct, and that was an exception. So here now we have the state action, right? The state basically saying, you, Mr. Smith, violated the laws of Oregon, therefore you're not qualified for unemployment insurance, even though you are doing this peyote on the basis of your religion. So, very sympathetic plaintiff. He was represented, by the way, by the ACLU. And the ruling was the same as in Reynolds. And rule number one is that there is no exception from complying with a generally applicable law. So the law about not taking illicit drugs didn't apply only to religious people, didn't apply to any identified person, it applies generally. Okay, so the law wasn't picking on Mr. Smith or his religion. If it incidentally infringes upon religious exercise, it's still okay as long as the law is neutral as to religion. So that's the general rule. There is a footnote to this that I will try to get to if I have time. But in short, after this case was decided, there was a big uproar in America. Mr. Smith is a very sympathetic character. And there was a bipartisan effort in Congress to enact the Religious Freedom Restoration Act in 1996, so about 2-3 years after this case. And that created a further protection for religious exercise in America. And you've heard some of these laws being passed. For example, in Indiana, Governor Pence, when he was governor, passed a law that essentially tried to shield businesses and individuals from discriminating against, among others, gay people based on your religious freedom. But for now, this is the law in the Supreme Court. On to the establishment. I'm not going to go through a lot of cases here. But the Establishment Clause is essentially what everybody talks about when we say separation of church and state, right? No official state religion. So what the Establishment Clause does for the benefit of churches is, for one, it will never get into church doctrine. So for example, it will never say, you, the Catholic Church, you have to hire women priests or gay priests. This is something that is germane and central to a church, and the Establishment Clause will never allow a state to do something like that. Another thing, there's a ministerial exception. And what this is, there's a recent case, for example, where a female teacher of a Lutheran church who was a called minister. So there are called ministers and there are lay ministers. And she was a called minister, which means that she took all the steps to become a minister. And she was a teacher. She developed an illness, narcolepsy, and so she had to go on disability leave. In the meantime, somebody took her place. When she came back, the church refused to rehire her, saying that they hired somebody else. And when she threatened to sue, the church immediately terminated her. So she went to the EEOC, which is the Federal Equal Employment Commission, Opportunity Commission, EEOC, and sued for violation of their laws, anti-discrimination against pregnancy discrimination. And the court, again, we go with the Supreme Court, and the court said not that the church didn't violate her rights. The court said that the law doesn't apply to the church, right? And why? Because the church has to have ultimate autonomy in choosing who the ministers are. So here we have an exception. This is, by the way, similar to the exception that was given to Hobby Lobby. You remember that case. Hobby Lobby was an organization, it's a for-profit organization that says that they don't have to offer health care, particularly contraceptive health care, to their employees, because the owner of Hobby Lobby was a religious employer. But anyway, so others, school prayer, obviously, right? You can't have a public school mandating prayers. That's an Establishment Clause violation. Monuments, creche, crosses and things like that. They may or may not be allowed depending on how they're displayed. And then creationism. Johnson Amendment, this recently came into the news. This is the law in the mid-50s, named after Lyndon Johnson, that disallows churches from, because they're nonprofits, from advocating for or against a politician. President Trump actually just recently issued a rule that tried to soften that as to churches. All right, all right, I'm getting to the end of my first section. So there's a cheat sheet I provided that gives you an idea as to how to look at religious liberty in America. So if the issue regards church doctrine or its ministers, you have ultimate religious liberty, right? Government will not interfere. If you're a religious affiliated organization, not a church, but maybe a hospital or a religious school, other religious nonprofits, then you have also more protection from infringement. But beyond that, in the political arena, for generally applicable laws, what we saw, and especially laws that protect against discrimination, then there is less protection, right? The idea here is that if you're a religious person or an organization, but now you're in the public sphere, right? If you're a shop, if you are a business that is a public accommodation, then you can't then even there, right, not in the church, but even in the public say, well, my beliefs are against gay marriage and I'm not going to sell, flowers or whatever. So that gets to the next case. I'm wondering now if it's okay to take some questions about what I've covered before we get to the cake shop case. So there's one behind you there.
Yeah, I was just wondering where the, taxation benefits come in with religion. Why do religions have exceptions for paying taxes on a variety of different things?
Yeah, so this gets to an Establishment Clause question. So, as you know, there are many nonprofits, including religions, and religions are nonprofits. Any 501c3 is a nonprofit, C6, C9s. And so the idea there, and I don't know the exact cases when it happened, but if you can say that if you discriminate against religious nonprofits by making them be for-profits, but not discriminate against secular nonprofits, then that is a Establishment Clause issue, right? Because you're picking on religions, but not on other nonprofits. Now, could the government say, well, all religions have to be taxed and not be subject? I think they can, because you're not picking on any particular religion, right? So you have a violation of the Establishment Clause, one by favoring one religion or another, or by in a very hard way discriminating against religion versus secular. So there's two different ways, but anyway, that's the general answer. Any other questions?
You mentioned Hobby Lobby.
Yeah.
They had their ad in the paper today. Now, what became of this problem with the Hobby Lobby?
Okay. So when I mentioned that Congress passed the Religious Freedom Restoration Act, so that basically says that after the Smith case, which everyone was all mad about, that religious liberty should be elevated, right? So if somebody says, hey, this is really affecting my religious liberty, even though the law doesn't pick on religion, right? It just happens to hurt me when I, a religious person, has to comply with this law. What Congress says is that, even as to laws that are neutral, that are generally applicable, if it happens to have a effect on a religious person's exercise, then the courts should give that exercise more weight, right? So maybe give an exception. What Hobby Lobby did back in 2014, when it was decided, was that Hobby Lobby, by the way, is a corporation, is a for-profit corporation, just like McDonald's. And it's not a small corporation either. It is closely held in the sense that it's not public, the shares are not publicly traded, but it is owned by a family and it's not publicly traded. The owner is somebody who's very, very religious and says, hey, Obamacare, I will offer insurance for my employees, but I'm not going to offer contraceptive coverage. And so they said that Hobby Lobby, even though it's a corporation, has religious freedom rights, which is unusual, right? It's like Citizens United saying that a corporation is a person for purposes of spending money and free speech. So it's very similar. That's what the Hobby Lobby case does, unfortunately.
Your slide just had the single word creationism.
Yeah.
So is that saying that, because I always think of it as churches not, or schools not teaching creationism, is there any other, how else does creationism come up?
No, you're exactly right. That's how it comes up. So there are still efforts today for people to have public schools teach creationism alongside with evolution. And the court has said very clearly, it's not a Supreme Court case, but it's a appellate court case in Pennsylvania, another one. But anyway, it says that creationism, intelligent design, they're all based on religion, and you can't teach it because it's using public funds in a public school to teach school children a doctrine, basically. So that's an Establishment Clause violation. You can do it in private schools, you can't do it in public school.
Yeah, in the Constitution there is equality for men and women now, but then the church violates that, as you pointed out. So how does the Constitution reconcile with that equality?
You're talking about the contraceptive coverage?
Yeah, not just contraceptive, like everything, like our right to vote and all this stuff. And women are not equal as of yet in many aspects, but we are trying to get all this equality being in the Constitution, and the church or any other religious institutions are violating left and right. So it seems like...
Well, right, for example, picking ministers, right? Yeah, that's true. Yeah, well, the answer, I'm afraid I already gave it. I mean, because of the hesitance of the government to step in and say, the Mormon church, for example, you have to allow women to be priests. It's not going to happen. And I have to say, I don't think it should happen, because I think that there should be religious autonomy. Churches, you don't have to join the church, right? But if you want to join that church, regardless of what it believes, you should be able to join it. And so I personally wouldn't want the government to say, no, churches have to believe this. That's also tyranny. So, but in many other situations, you're right. Unfortunately, oftentimes, and we'll talk about it when we talk about the cake shop case, is that if you can allow a baker to discriminate against a gay person for their wedding because of religious beliefs, what if your religious beliefs say that I don't think that women should work, so I'm not going to make a cake for a retirement party for a woman, right? So we'll talk about that actually.
Yeah, but what I'm saying is also the Mormon church.
Use this.
In the Leland versus U.S., he was saying that in the religious paradigm, the man can marry, practice polygamy, but not the women. So that's already a violation.
I agree. I'm not going to argue with that.
No, but I'm saying, how does the U.S. Constitution?
Actually, it gets a little more complicated because gender equality actually was not part of the U.S. Constitution. We have gender equality in terms of the Civil Rights Act in the 60s, for example, but it's not one of the basic freedoms. We're a patriarchal society in history. I'm sorry, that's the only answer I can give you. Yes, please.
Yes, I'm just curious. You mentioned that creationism is a doctrine, basically a religious doctrine, therefore it's...
The court said that, yes.
Sorry?
Yes, the court said that.
Right,
yes.
And in fact it is
a
doctrine. So I'm curious as to why abortion doesn't fall under the same thing, because that is a religious doctrine. There are many religions that have no prohibition against abortion, and so by mandating or prohibiting it, you are thereby establishing state religion, or state doctrine based on religion.
Yeah, That's a good point. It gets a little complicated here, but the basic rule is that even if you raise religious violation issues, the government still has the ability to override a religious practice, even if the religious practice is deemed to be compelling. So, for example, if we have a religion that says, we believe in human sacrifice, right? No matter how strong you believe that, the government and if the government says yes, this is a religious exercise, and you apply the highest bar against the government to impede that, the government can still win by saying that we have a compelling interest, and that compelling interest will supersede any religious practice. So in the abortion case, for example, I think there were some religious arguments, but I'm not sure in Roe v. Wade or not. The government basically said there's a compelling interest, a privacy interest for abortion that supersedes this. I have other comments about Roe v. Wade, but they were basically legislating from the bench, pretty detailed doctrine. But anyway, that's my short response. It's a very complicated question, but a good one.
Well, you have 15 more minutes
Okay.
to 12.
Alrighty. Well, this is all right. Well, let's go to the case here. Jack Phillips, he's the baker, and Charlie Craig and David Mullins, they're the couple. So let me give you the facts. They walked into a baker, his shop, about 5 years ago, and they wanted to have order birthday cake. Mr. Phillips, I have to say, I'm sorry, wedding cake, yes, wedding cake. Mr. Phillips is really an artist, right? And I have to say, as a person, he's a good person. He's anti, gay, but he sincerely believes that. Masterpiece Cake Shop, for example, which is the name of his store, Master refers to, in his mind, Jesus. Right? So he really believes in this thing. He believes that God gave him the gift to create and the artistic talents, and he wanted to use his talents to glorify his God. And his whole shop, is really based on this idea that he's serving God using his talents, right? When the couple came in, and there was about a 20-second conversation, as soon as Mr. Phillips realized that they were asking for a cake to celebrate their wedding. Their wedding was in Massachusetts, by the way. It wasn't in Colorado, because at that time, Colorado didn't allow gay weddings. They wanted to come in to celebrate their wedding. Mr. Phillips says, I'm sorry, I'll sell you anything. I'll sell you cupcakes and other things off the shelf, but I won't make a cake or create a cake for you. And so the couple walked off. And so the couple then went to the Colorado Civil Rights Commission to complain. And in Colorado, there's an anti-discrimination law. Almost every state has it. California has one as well. Their law actually includes laws against discriminating against a person because of sexual orientation. And it applies to public accommodations, right? This is a term of art. It basically says that if you are like a retail store, if you're out in business and you're selling stuff, then you cannot say, I'll sell stuff to you but not to you, based on a certain characteristic, right? And those characteristics are disability, race, creed, color, sex, and sexual orientation. So it's anti-discrimination. So the commission looked at the case and said, yes, there was a violation. So these are the things that the couple has to do. They issued a cease and desist order against Mr. Phillips, saying no more discriminating. Whatever you sell to any other couple, you have to sell to a gay couple. You can't discriminate against them. And then Mr. Phillips has to train staff and also provide quarterly reports to the commission. So it's kind of onerous, and it's his own small business. But as a result of this order, Mr. Phillips decided that he can't take the risk, and he decided not to even bake cakes anymore. And that resulted in about loss of 40% of his business. So, like most issues, not most of them, sorry, a lot of issues, they went all the way to the Supreme Court. And by the way, this case hasn't been decided yet. There has been oral argument already in December, and most likely it will come down around June or so. And so there are two main issues in this case. One, Mr. Phillips' Masterpiece Cake Shop is arguing that there's a free exercise violation, right? So from what I already said, that's probably going to lose. And the reason is because the Colorado law, anti-discrimination law, doesn't pick out religions, right? It says everybody in Colorado. If you are a public accommodation, then you have to comply with the law. So no free exercise claim. The second argument is that he's saying that, well, this violates my free speech rights. And how does that work, right? I know you're going to ask a lot of questions about that. So does he have a free exercise claim? I said no. There's a big footnote here based on what I said at first, the Religious Freedom Restoration Act. In a nutshell, I'll try to get to it, but in a nutshell, really, the commission in Colorado actually did some things that hurt its own case. For one thing, there was a commissioner that expressed at some point some animosity toward religion, basically saying that, oh, I'm not going to stand by here while I'm a member of this commission and allow religious people to use their bigotry to discriminate against gay people. Okay, I shouldn't have said that, because it looks like he's picking on religion, right? And also in another situation, a couple of situations, when there was the opposite thing that happened, a very religious person basically is going around cake shops saying, hey, please make me a cake, and they know that the baker is gay, saying, make me a cake that quotes Deuteronomy and says, you know, homosexuality is an abomination or something like that. And so those bakers refused. And this also went up to the commission, but the commission didn't say, no, you have to bake the cake. The commission says, well, this is offensive, and so the baker doesn't have to comply with that. So now it looks like the commission is picking on religion, right? If it's doing that, then it's no longer a law that is generally applicable, right? It's a law that says, if you're a religious person who's discriminating, you get dinged. If you're a non-religious person who's discriminating against religion, then it's okay. But anyway, that's kind of a footnote. Whether the case is decided on free exercise will depend on whether those facts are taken seriously. So, I'm going to skip that. Okay, what is this free speech idea? Okay, so the commission's action constitutes compelled speech. This is the cake shop's argument, right? Demanding that he, Phillips, as an artist, design custom expression that conveys ideas that are at odds with his own faith. So he's basically saying that the government is compelling him to express something that he disagrees with. Okay, so free speech can be violated in a couple of ways. One, the government forces the person to express a message the person deems objectionable, or punishes a person for declining to convey a certain message. So, is there any backing for this? So there are some cases that the cake shop can cite. This is the Barnett case, 1943. I won't go through the details, but basically these are Jehovah's Witnesses kids, okay? Cute young kids. Their parents really are not very happy that the kids have to say the Pledge of Allegiance in school, public school. And so the school expelled them. And so the family sued. And what the court says that, a very famous line here, says, if there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein, right? So I think we all agree with that, don't you think? I mean, we don't want oppression, we don't want the government to force us to take oaths that we don't believe in, and so forth. Another case, this is Woolley versus Maynard. This is, I don't know if you know this, but this is kind of the state model for the state of New Hampshire. Another Jehovah's Witness family saying, oh, I don't believe that. And he was cited for covering live free or die. Just the words though, not the rest of it, but just the words. And he was cited, so he sued. And the Supreme Court was on his side, saying that the First Amendment includes both the right to speak freely and the right to refrain from speaking at all. And I'll skip this one here. So, but the threshold question is, what is this speech? Is baking a cake speech? And I'll go back to the previous slide. And I think that the reason why this is important is not really just about baking a cake, because if the baker's actions can constitute speech, and because you're saying it is speech, therefore I deserve an exception under the First Amendment, free speech, then why not a cook or a dressmaker, makeup artist, florist, tailor, photographer? Are all these people also speaking in some way, sending some kind of message? So this case potentially is much broader than just a baker and just about weddings, because if it's a wedding that the person disapproves because of religion, well, how about the woman, right? How about a bar mitzvah? If you think that, if you're a Christian and you think that the Jewish religion is wrong, can you say, well, I'm sorry, I don't serve celebration for bar mitzvah. I'll serve you as a Jewish person, but I won't serve this particular occasion because it violates my religious beliefs. So it's a case that has much more broad ramifications than just a baker and gay weddings. So the question though is, are these cases correct in terms of supporting Masterpiece Cake Shop? And these are some of the questions that we would ask in weighing his arguments. Does the cake include words, right? Because remember, their conversation was 20 seconds long. They didn't even talk about, well, is there going to be something that I have to write on the cake, or is it just a cake? Mr. Phillips doesn't actually decline services for just gay people in general, right? So he can, I think, justifiably say that he's not homophobic in that a gay person can buy anything that they want, even a custom cake if it's for, let's say, a birthday party. But Mr. Phillips specifically believes that marriage is between a man and a woman. So what he is saying is that his opposition is based on the message, not on the status of the individual. Is Mr. Phillips compelled to accept gay marriage in the same way that the Barnett kids were compelled to pledge allegiance to the United States because of the anti-gay legislation? That's another question. The answer is no, by the way. Nobody says that he has to believe it. He can post signs in his shop to say that any cake that I make for a gay wedding does not reflect my personal views. He can say that. Is this like racial discrimination? You can make an argument, yes, right? If in fact, the case that I skipped, maybe I should have skipped it, this case here, this guy, Maurice Bessinger, he owned a Piggy Park drive-in back in the 60s. He, like Mr. Phillips, was very, very religious. You know, in his barbecue shops, he had these religious tracts that talked about God intending to separate the races. And so his business was kind of merged with his religious beliefs. But the court said that, no, you know, you still have to comply with the civil rights laws. You cannot bar blacks from your shops. But the court did not say you have to believe that, you just have to serve them. Okay. All right, so I'll cut to the chase. I think this is my opinion now, because the court hasn't decided yet, but I think Mr. Phillips's arguments are based on cases that are strictly speech codes, right? The anti-discrimination law in Colorado, it says no discrimination. It doesn't say you have to say certain things or believe anything. But the Barnett case, you're having kids, you know, pledge allegiance. The state is dictating what the kids have to say that comes out of their mouth. Live free or die. The state, you can say, is making people become a human billboard for the state's motto that you may not believe in, right? So, are those cases pertinent? I think the other cases that the state and Mullins uses is more pertinent. This is U.S. versus O'Brien, and you probably can tell what he's doing. He's burning a draft card. And there's a law under the Civil Service Act that says you can't burn your draft card. It causes a lot of inconvenience for the government administrating the war, among other things. And so, but Mr. O'Brien says that, hey, you know, this is free speech, right? There's a reason why I'm burning this draft card. I oppose the Vietnam War. But the court ruled against him 8-1, and the reason was because it says, well, this law is really not about speech, it's really about conduct. It's really only about, hey, you're burning these draft cards, we're making it illegal, right? Now, it incidentally affects you making a speech or using this as a way of communicating, but it's not targeted towards speech, it's targeted towards conduct. In the same way that the Colorado law says, hey, if you're in business, no matter what you do in business, that conduct is governed. If it happens to affect your speech, well, so be it, but we're not regulating speech, we're regulating conduct. All right, and there's another case also, and this is also a Supreme Court case. This is Rumsfeld, you may recognize him. FAIR is an organization of law schools. Right? And the law schools at that time, they were opposing the don't ask, don't tell policy of the military. And they didn't want to have military recruiters come to their law school doing recruiting. But there's a law called the Solomon Act that says that if you take public funds, if you take federal funds, then you cannot discriminate against military recruiters. You have to allow them to come, right? But the law school says, well, but you know, you're making us advertise it. You're basically forcing us to say, hey, we approve of these recruiters. But the court says, no. Here again, this law is a law on conduct, saying, if you're accepting funds, you have to allow military recruiters. Does it force you to accept the DOD's, Department of Defense's policies? No. You can make speeches about it if you want to, against it, but the burden on your speech is only incidental. Okay, so anyway, I hope it's not too complicated, but what the state of Colorado and Mullins and Craig are saying is that this is a law, the anti-discrimination law, is a law against conduct, not against speech. The infringement upon speech is only incidental. So, how the court will decide, we don't know, but it has large implications, and we'll see by about June or so how they decide. So, and I'd be glad to take questions.
All right, anyone
comments?
have questions?
You mentioned you mentioned that these institutions could not compel speech. During the McCarthy era, weren't all universities required to have their professors and employees sign a patriotism? I don't know what to say, but
right. Yeah. You know, there are cases that deal with the issue of compelled speech, taking oaths as a condition for employment or other things like that. And largely that has been deemed to be not constitutional now. There was a case against Mormons as well, after Reynolds. They basically said that the person who's a Mormon was prosecuted for an oath in which he was lying. He had to make an oath that he was not practicing polygamy, and it turned out that he was. And this was a condition of getting, I can't remember what the condition was for, I think it was even voting. And the court rules against them. But about 100 years later, the court overruled that, essentially saying that no, you can't compel somebody to believe in something, right? You might reach the higher test that there's a compelling interest, right? So sometimes you do have to, for example, when you go into court, you have to raise your hand saying, you know, I swear to tell the truth, the whole truth, blah, blah, blah. That's required, right? Because there's the view that there's a very compelling interest in doing that. But otherwise, yes, you can't allow that.
did anybody sue?
I actually don't know the answer to that question. I haven't studied that. Yeah.
Okay.
Probably no. given the time. Go.
In your first talk, you mentioned that the federal government can intervene based on practices. So what I'm saying is that a lot of these are practices.
Yeah. So and in fact, the law has evolved, and so the religious freedom, free exercise, is actually expanding as time goes on, which is expected. Free speech, right? That is suspended very much now. Nazis marching in Skokie, Illinois, and so forth. So the constitutional law is such that eventually, over time, they tend to expand those rights. At the same time, though, unlike speech, the Establishment Clause is a break on the exercise. There's no equivalent free speech break, but there is an Establishment Clause. So that's really what most religious people complain about, is the Establishment Clause. I think she had her hand. Yeah, go ahead.
It's not related to religion, but this topic reminded me of a sign I see frequently in businesses such as Whole Foods, big and the small businesses, that make a clear, big statement saying they reserve the right to refuse service to anyone.
Yeah.
Any comment on that? How can they get away with that?
Yeah. No, remember, the anti-discrimination laws only forbid discrimination based on certain characteristics. Right? So
But they can refuse service to anyone they wish.
you can't apply that law in a way, your sign or your rule in a way that discriminates or violates. So, for example, you can't use that sign that says, okay, I'm only going to serve women, but not men. That would
But
be a
it's
violation.
such a general gray statement that they could cover themselves in any way, right?
No,
I mean,
no.
because they're saying we
No, that
reserve
would-
the right to.
Yeah, that would not be allowed. You can do that. I think it's wise to do that, by the way, because if somebody walks in with no shoes, no top, you can, there's no constitutional right to be topless or to have no shoes. You just have to, you can't use that sign in a way that violates the law.
Well, they might say, no shoes, whatever, or somebody brings an animal in that is not a service dog and insists it is a service dog, they may say, no, you can't do that, or whatever.
Yeah.
But the thing for me about this religious freedom thing, or whatever, it really annoys me, because it's really a religious freedom to discriminate.
You're right. The religious exercise has been formulated originally to protect you from the government's intrusion on your practices and your beliefs. So it's a shield, right? So now the evolution, as I said, now is used as a sword. So now it's used as a sword to discriminate and say, hey, it's my free exercise to discriminate. So I think that's a fair way to describe it. Yes.
So I'd like to approach this from the aspect of free speech and relate it to other types of what has been claimed as free speech, not necessarily in the religious sphere, but in doctrine, which there are political doctrine as well as religious doctrine, and say that there are some expressions which people try to protect as religious, but which in fact might be considered, and I believe there are laws about this, incitement to violence or hate speech or things like that. So, by for example, two examples. One is you said that for example, you put up something that says, sodomy or homosexuality is an abomination, and then you could quote and say, they must be stoned or something like that. Is that not an incitement to violence, and therefore would not be protected as free speech? And a more relevant, I think, you actually mentioned, for example, Nazis marching in Skokie. All right. So what? And I have very personal interest in this. The Nazi doctrine and the Nazi symbol is an actual death threat. So how can that be protected to a certain people? In fact, Nazi says death to a certain group, right? We have 6 million examples of that. So why was their right to do that protected as free speech when in fact it should have come under either incitement to violence or direct threat, which I believe is not allowed?
I think you raised the balancing act. There's no bright line, but you're exactly right. In order to inhibit speech in America, and I'm talking about government inhibiting speech, the government has a very high bar to surpass. It has to say they have a very compelling interest in order to suppress the speech, right? So imminent harm is, shouting fire in a crowded theater, that kind of thing, or immediately inciting to violence. Those are not protected. The parade in Skokie, it was deemed by the Supreme Court, and you can argue both ways, but that was not something that was an incitement, that was an expression, and that should be protected. And remember, the ACLU supported that on the basis of protecting our freedoms. But you're right, these can be very sensitive balancing acts that the court always has to do.
Jerry Grass, I was thinking about two different situations. Suppose the baker was the only baker in the city. If the baker's allowed to say no, then they can't get their cake. If, on the other hand, you had a baker on every block, then they could just go to another, go down the street and get a cake somewhere else. Has anybody considered the difference between those two situations?
Yes. In fact, in an oral argument that was raised, and you can easily see a different situation if, let's say, you're in Alabama, or you're outside, you're a military base, right? And there's only a baker or maybe two bakers in the whole area, and a military person would have a hard time trying to find, if you're a gay person, a baker that would allow, this cake, so or bake the cake. This is not the situation here, but if it were, then the analysis would be that, well, in this situation, by the way, let me comment first that I think it's horrendous that one has to shop around to see who's not going to discriminate against me. So I don't think that's a good idea, but it is different here. In fact, the couple actually was able to get a free cake from a nearby baker in Liquid, Colorado, because of this publicity. So there were a lot of bakers that were willing to serve them. And that is actually an element of the court's decision when the judges decide as to, well, do we have to rule against the baker here since, hey, there's so many bakers that are allowed. It would be a different situation if it were in, like I said, Louisiana or something like that. It is a factor, yes. Good question.
Is it also a factor in this case where you said that the baker was willing to sell an off-the-shelf cake to the gay person, but this is a situation where he personally would have to handcraft a cake, so this really has less to do with what his business is willing to do, but what he personally, as a craftsman, is that, how does that factor into the decision?
Right, you pointed to the crux of the free speech argument, right? Because he said that he would be willing to sell an off-the-shelf, cake, which is, by the way, not very practical, right? Nobody walks in and says, I want this one, my wedding is tonight. But it goes to the very idea of him using his expressive talents, which is the speech part, in order to have to support this wedding. So yes, it does matter very much, and I think the best way to construe the facts most favorably to the baker, that's his position. He says he doesn't want to use his talents in order to support the wedding. Wait for the mic. Oh, great questions.
But then, I suppose a barista could say, it's my talent that when I give you coffee because of the pattern of the cream I put on top. Or a house painter could say, yeah, but the way I paint the house is different. You don't notice the brush strokes. Or a mechanic could say, this is an art, the way that I take care of your car. Or a surgeon could say the same thing, that this is an art. And the same thing with marching. If a person is marching and they approve of that, then the baker could say, you're approving an act of free speech. What I'm doing in baking this cake is the same thing. And I'm afraid that if this passes, it'll have disastrous consequences, don't you think? I mean, then a person could say, I'm not going to serve blacks anymore. They're going to have to go to the back of the bus because we believe that this is against or the back of my Uber car or whatever. They'd say this is my religious belief.
Yeah, and that hasn't been raised before by the Piggy Park guy. Yeah, so I agree with you. I think you're exactly right. I think that as long as a believer can describe his or her conduct in the form of this is an expression or some kind of artistic expression or just expression, then yeah, if the court rules in favor of Mr. Phillips, I think that's going to open the door. It depends on how they write the decision, but this is the issue, and this was argued by the ACLU attorney and the state's attorney in oral argument during this case. Good point.
Yet another question. Do you think that this might have an impact on medical services where a physician wouldn't be able to opt out of medical things that are legally available to a patient, but the doctor doesn't believe in, such as assisted suicide or abortions and things like that?
Or transgender surgery.
Transgender surgery.
Yeah.
Or tattoo artists, being compelled to put tattoos on people that are offensive to their religious.
So this actually gets back to the Religious Freedom Restoration Act. So this is not speech, right? I don't think you can stylize operation as speech, but you can go back to I'll call it RFRA, that law. If that law is enacted in a state where you live, by the way, it hasn't been enacted in California, nor in Colorado, but if there's a law, let's say Indiana, right, that has passed that, then you can have situations where a pharmacist can say, well, I'm not going to dispense anything like, an abortion pill or something like that, because it offends my religious belief. Then the questions become, okay, can I refer to another pharmacist and things like that? So that analysis under RFRA does not require you to try to fit within this idea of speech. As long as you say, this offends my idea of religious liberty, then I can somehow get extra protection. So yes, so RFRA is, in the beginning, Chuck Schumer was the supporter of it, and it was totally bipartisan. I think there was one vote against it in the House, and it was almost unanimously passed. But again, this was a shield, intended to be a shield, now slowly evolving to be a sword.
All right, time's up for Q&A. Let's thank our speaker.